Good afternoon, everybody, here at the Law and Crime Network. We have a jam-packed, and I'm telling you, a jam-packed afternoon for you. The jury decides to recommend the death penalty, and you're just listening to the judge imposing that sentence and then setting an execution date of June 7th, 2019. So that's just in a little more than a month. I want to bring in my panel right now. Ann Bremer from California and Roger Foley calling in, Skyping in, I should say, from Florida, both criminal defense attorneys. So I was really shocked, I got to tell you, that you hear this judge setting an execution date for about 5 weeks from today. And you have to remember, this is a defendant who is pro se. She's representing herself. And while he did advise her of her rights to appeal, I'm not sure, to be honest, if she is going to file an appeal. Is it possible that she could be executed in a month's time, Roger?
It's possible. I don't know how likely it is, but I mean, she put up no defense. She gave no closing argument. She crossed nobody. So right now we have no inclination that she plans on appealing. And remember, she would have to agree to allow the public defender to begin the appellate process for her. So who knows?
Okay, and I just do want to make one correction here. The death date isn't the 7th. He set it between June 7th and the 14th, so in that week time span. Thank you for that correction there. I'm sorry I was incorrect with that information. And something just so horrific about it is all the warning signs that were missed. And Danny Porter touched upon that during his opening statements of the death penalty phase of this case when he's talking about a prior conviction that Tiffany Moss had for abusing this little girl several years ago, and that was actually brought up during the guilt phase of this trial. But interestingly, he said you can consider that during the sentencing phase. Did any of you have a problem with the fact that her prior conviction of abusing this little girl was brought up during the first part of the trial?
Normally you don't see that. Oh, sorry.
Go ahead.
Go ahead.
Normally you don't see that. I mean, there has to be a ruling from the court to even allow that to be permitted in. But again, in Georgia, perhaps the law is different on a prior bad act or a prior crime. Normally, it's simply that this person has been convicted of a crime if they're testifying. And in this case, she didn't even testify, so it's a little different. I don't think we would see that here in Florida.
All right, I want to bring back in my panel, Ann Bremer, Roger Foley. They are joining me via Skype. I want to ask you first, Roger, do you have a problem with jurors imposing the death penalty on a defendant who is pro se?
You know, that's such a difficult question. I'm so used to the judge making that call. But I can imagine how difficult it is for the jurors. We already have a debate in this country in regards to whether the death penalty should ever be given. But no less on a pro se litigant who has no legal experience, no training, and literally says nothing except yes, Your Honor, or no, Your Honor, throughout the trial. She puts on no evidence, no case. It's very difficult, but what she did, what she is alleged to have done, and what she has now been convicted of doing is as heinous and horrible as a crime that I can imagine. You know, starving to death a 10-year-old girl over time to the point where she dies. And just the way that prosecutor explained what the experts shared about the different stages that this young girl went through as her stepmother did this to her, it shocks the consciousness. And yeah, it's just tough case. Yeah. It's tough to listen to or even comment on. It's so horrible.
It really is. And then you have the fact that after this little girl died, they set her body on fire and then placed her in a garbage can. Now that's really, really upsetting because, I mean, it's horrible what they did, you know, and then setting her on fire, but just leaving her in the garbage, like her life is not even deserved of a proper funeral. You can certainly understand why jurors probably found this to be a death penalty eligible case. Oh, I thought that those were very powerful words from Danny Porter. He really doing a good job throughout this trial, not only laying out the facts, but also bringing out the emotion here of what happened. One of my colleagues, Linda Kenny-Bodden, a host and a criminal defense attorney, said she thought that this was a trial of suicide by trial. In other words, she thought defendant Tiffany Moss was trying not to put up a case because she wanted to be put to death. What do you make of that argument, Roger?
No, I think that's very likely since she didn't put up any argument. But I guess when she was speaking with prosecutors, when the public defender was there, she could have asked. I mean, we have heard in the past of cases where someone was facing a possible death penalty and they actually requested it. It's always been a situation where we're curious, why would someone ask for death? And there's all kinds of arguments for that, but she didn't do anything. She just said, no, I'll go to trial and represent myself. And I think it is. I think it's suicide by jury or death by jury. And I think she's got a very good point there.
Well, it's going to be interesting to see what happens as we approach the date for which she is set to be put to death, which is between June 7th and June 14th. I also wanted to mention that according to the Death Penalty Information Center, this is the first death penalty verdict in Georgia in 5 years. So we're going to continue to monitor developments in this case. We're also going to take you back live inside a trial in California, as well as the Robert Kraft hearing, which is expected in about an hour's time. Stay with us. We're going to take a quick break, but we'll be back in just a few minutes.